All right, well, we'll go ahead and get started. It is right after 7 o'clock tonight, and we have legal issues in child custody cases with Valerie McWilliams joining us from Land of Lincoln Legal Aid this evening. And I want to thank everyone for joining us. And my name is Trisha Duzan. I am the Adult Services Manager here at the Champaign Public Library, and we're so excited to bring this legal series to you today. Few features I just want to go over if you're just joining us. We will have the chat to handle any technical questions or any other questions you might have, and we'll hold those till the end so Valerie can take those towards the end. And as you may know, we are currently doing mostly webinars here at the library, so you can be sure to check out our YouTube channel for the latest programs we're offering, and our events calendar always has things that you can register for as well. So we'll go ahead and get started. I'll go ahead and introduce our presenter this evening. So we have, Valerie McWilliams joining us this evening. She's going to go over child custody legal issues regarding children when parents separate. Legal aid attorneys provide eligible residents with high quality civil legal services in order to obtain and maintain their basic needs. So she's going to share a presentation, and again, we'll take questions if you have any at the end. And I'll go ahead and let you get started, Valerie. Thank you.
Okay. All right, so again, my name is Valerie McWilliams, and I've worked at Land of Lincoln Legal Aid for 38 years. Most of that time, I've done some family law related work, but for the last 3 years or so, I've done almost exclusively order of protection work and also family law cases that are related to order of protection cases, cases where there's abuse going on. I work in about 6 different counties, but tonight I'm going to be focusing on a combination of things that are applicable in all of the state of Illinois, and then also some things that are a little bit unique to Champaign County. Land of Lincoln as an organization serves the southern 65 counties of Illinois. We have 5 different offices, and I work out of the Champaign Regional Office. And we can go ahead and get started here. All right, so the first thing is to get our terminology straight. Custody and visitation is the way we usually have historically talked about the legal status of children and parents and their relationship to each other when the parents are separating. But several years ago in Illinois, the official name of this was changed. And so now when you go through a court process dealing with these issues, it's technically called allocation of parental responsibility. And there's 2 parts to allocation of parental responsibility. There's decision-making and parenting time. And so the process as you move forward has to address resolution of those issues. Although sometimes we'll still go back and talk about custody and visitation because that's what most people are generally familiar with. And this type of issue, these custody issues or allocation of parental responsibility, can come about in several distinct areas. Most traditionally, we think about this happening in the context of a divorce case. And as of January of this year now, the way those cases are coded in the court system are using the letters DN or DC. So if you file a case this year, it would be 22 DN, and then whatever the number is for the case that has been filed for that year, and then the numbering system starts over in the new year. DN, I think, just stands for divorce with no kids, and DC stands for divorce with children. And so again, that's sort of the most typical context for having these cases arise. But sometimes the issue of parenting time is going to come up first in the context of a child support case. So there are independent child support cases that are sometimes initiated by the state the Healthcare and Family Services Division of the state of Illinois has some responsibility for seeking child support when there's a parent that's no longer living in the household that is capable of that support or should be capable of that support. So they may initiate a case, and then a lot of times when that happens, the parent who is being required to start paying child support will say, well, what about visitation? What about my parenting time? And so then that leads to the kind of the same process that we're going to talk about that would otherwise start in the context of a divorce case. Also, independently, parents who are not married to each other can initiate a parentage case. And these are usually coded as F cases, as are the child support cases. And so in a parentage case, we have unmarried parents, and sometimes parentage will have already been legally established through something called a voluntary acknowledgement of paternity, which happens often at the hospital with non-married parents. As long as everybody's in agreement, people can sign paperwork, and parentage is legally established at that point. There's sometimes confusion about DNA tests as opposed to acknowledgement of paternity or a court finding of paternity. DNA tests aren't required if nobody's insisting on them, as long as both parties agree that that a certain man is the father of the child. Then forms can be filled out, and it has the effect of that person being the legal parent. Sometimes people do that when they aren't actually the parent, and there is a limited window potentially to reverse those decisions. But pretty much after 2 years, if people have filled out those forms, then they can end up being the legal father with the rights and responsibilities that come with that, regardless of the biological status of that individual. And then also in the context of orders of protection, I had mentioned that I do a lot of work in this area. And so if a parent is seeking an order of protection against another parent, usually what happens is in the first 3 weeks, there's an emergency order that happens outside the presence of the other party. They don't get advance notice of that. But within 21 days, there's going to be another court hearing where everybody goes back to court. And sometimes that order of protection is extended, and sometimes it's not. But if it's extended and there are children involved, a lot of times at that order of protection hearing, a temporary parenting time arrangement is going to be worked out. And then eventually, a lot of times that order of protection case will end up getting combined later with a divorce case or a parentage case for unmarried parents. And those other contexts are intended to provide a more permanent resolution of these issues. But a lot of times there's a need to do something quickly, especially if children are little. Judges are going to be very reluctant to have a long period of time when the non-primary parenting time individual is being cut off from access to the child. So it can happen in a variety of these settings, and then once you are talking about a divorce case or a parentage case where the parties are affirmatively trying to resolve these issues of parental decision making and parenting time, these are kind of the series of steps that need to be followed. So first, a petition, either a parentage petition or a petition for allocation of parental responsibilities, or a divorce petition will be filed, and it gets served on the other party. So when you initiate a divorce petition or a divorce process or a parentage process, you have to officially bring the other party into the case. You can't just text them and say, oh, by the way, I filed this case against you. You have to do, there's a different process involved in bringing that person into the case. Most typically, what happens is a summons is served with a copy of that petition, either at their home or place of employment. And if for some reason the person makes a diligent effort and is unable to get an address for that person, there is something called notice by publication, but that is kind of disfavored, especially if you're talking about custody of kids. It can be done, and sometimes one parent may have disappeared and the other parent has no reasonable way of getting a hold of them. But generally, it's going to start with service of a summons, or if the parties are really cooperating, the other party can file something called an entry of appearance, and they don't even have to go through that process of being served a summons by the sheriff. And then within 30 days, the other party needs to file an answer of some sort, responding to what they agree with or what they disagree with in the petition. If they don't file an answer and are not really participating in the process, then a judgment can still be entered against them by default. But typically, the other side will file some sort of answer, and then both parties are going to be required to take a parent education class, usually called something like Children First. It used to be that these classes were about 4 hours long, like two-hour classes. The parents would not go at the same time. They'd be going to different classes. And in Champaign, for example, they have been run by Family Service. Because of COVID, in most counties, including Champaign, have added online options to take that class. But it's still something that the parents will have to file a certificate of completion. And the point of that class basically is, as the name implies, it's just to make sure that parents understand that this process is going to be very hard on kids, and it's something that they need to make a priority, is trying to make this process of separation and moving forward with this new reality for them to try to make it as smooth as possible for the kids and put their interests ahead of the parents' interests. Then if the parties at that point have not kind of figured out what they're going to do with their parenting arrangements, including parenting time, parental decision making, then the next step is mandatory mediation. And a mediator is a trained facilitator whose job it is to try to get the parents to listen to each other and see if they can come together enough to have a plan for how to address these issues with their children. Sometimes mediation is waived, and that particularly is true in cases like the order protection cases that I'm involved with. If there's a domestic violence situation and there's a real power imbalance between the parties, usually mediation will be skipped. And if at this point there's still no agreement on who's going to be the decision maker for the kids and what the schedule of parenting time is going to be, then this next step, and at least in this form, is unique to Champaign County. The judge will appoint a limited guardian ad litem to do an investigation, and each party is required to pay $450 for this. And the guardian ad litem will talk to both of the parents, depending on the age of the children. We'll talk to the children and often contact a few more potential witnesses, people who would come to court if a trial was necessary, particularly people who have some extra knowledge about the kids and how they're doing, maybe a teacher or something like that. And then they'll make a recommendation. And a lot of times that recommendation will have the result of resolving the outstanding issues, because if a guardian ad litem has done an investigation and they're independent, it's not a lawyer for the mom, it's not a lawyer for the dad. Their job is to be the eyes and ears of the court, because judges can't go out and do these investigations, but they like to hear what an independent third party might say about these things. Well, so when they make a recommendation, it's pretty important that the parties listen carefully, and a lot of times their recommendation will have the effect of bringing about an agreement. But if that doesn't happen, then the judge will have to make a decision. And sometimes it's a combination of temporary hearings and permanent hearings. Sometimes there may have been a temporary agreement at some point in this process. It may have happened right near the beginning, or it may have happened on an emergency basis. And there are ways to get things quickly into court for relatively short hearings. When you're talking about a fully contested custody trial, that can take a lot of time and a lot of resources and time to prepare for it. And so that may take a long time, which is why a lot of times there's going to be a need to have some temporary orders along the way. And eventually, at the end of this process, you come up with something called a permanent order, but even a permanent order isn't necessarily permanent. As long as the kids are under the age of 18, it's still, once an order is entered, once the initial permanent order is entered, it's pretty hard to change it, at least for 2 years. But as circumstances change, it is still subject to review and modification if the necessary requirements for those changes are met. So a key thing that needs to happen in working through this allocation of parental responsibility is completion of this thing called a parenting plan. And this is a standardized form. I've shared this form with the library, so it should be available along with this presentation. And I think people who pre-signed up for this presentation were sent a copy of this. But it's really the completion of this is kind of the main thing that needs to happen as you move forward with the divorce. And so as the beginning of the form indicates, at some point, you may, like each side may be filling out a version of this. And the goal, again, ideally, is to get to an agreed parenting plan. And if that doesn't happen, then ultimately the judge will make a decision about what the parenting plan will be. But in most cases, I think the parties are going to get to the point where they get to an agreed parenting plan, hopefully, because it is best for the children. I mean, parents who separate are still going to have to continue to co-parent for many years. And it's a process that you go through, and it may be that it's a grueling and lengthy process, but it's still a lot of the steps in the process are designed to get the parents to kind of move towards that agreement, if at all possible, because the parents are going to know more about their kids than can ever be communicated to a judge. And hopefully they can get to the point where they're working together to come up with a solution that's best for their children. Now, even before you get to the issue of who's going to be the official decision maker in certain categories, the reality is that even if one parent is the primary parent in terms of the time that the kids spend with the parent, and in these categories that we're going to get to about the official things that somebody needs to have responsibility for making decisions for. Regardless of that, all parents are going to have certain rights and responsibilities. And so one of those areas where, regardless of who's the official decision maker under the allocation plan and who has the kids most of the time, when the children are in the care of a particular parent, that parent is going to be responsible for what's called day-to-day decisions. And that would include things like just getting the kids clothed, and them having to different hygiene issues. If somebody scrapes their knee, getting the bandage on, those kinds of things. And generally things like discipline would be the responsibility of the parent where the kids are at the time, because those things can't wait until the other parent comes and picks the kids up because it's their turn to go back to the other house. Now, I have seen cases where there's disagreement on the use of corporal punishment, and so that might be something that needs to be ironed out in the parenting plan. But in terms of minor correction for the kids, that's going to happen regardless of who's the official decision-making parent. In addition, each parent is entitled to have healthcare provider information, have access to medical records, unless there's some reason that that's denied to a particular parent. But the general starting place is that both parents have access to medical records, both parents have access to school records, and both parents need to be notified if emergencies come up and if there are travel plans, those kinds of things. So, and there are also these things that are considered to be significant decision-making categories. There are 4 of them officially that have to be addressed in the parenting plan for the parenting plan to be complete. And these are areas where there could be joint decision-making. And there are some parents who are separating that are that capable of cooperating with each other when it comes to important decisions for their children. But in other cases, the parents will not be able to communicate that effectively with each other. And so, if there is the decision made to have all these things be joint, then part of that process is to, both the parents will have to go to court, and the judge will have to be persuaded that these parents are capable of these joint decisions. And again, coming from the domestic violence context, generally speaking, that this will not be an option in those cases. If there has been a history of domestic violence between the cases, then it is very unlikely that a judge would agree to joint decision-making as a viable alternative. But sometimes parents agree to do some of the decisions together, and other ones leave primarily to one parent or the other. Anyway, these are the 4 categories that have to be addressed. Education and health are 2 of them. So education would include, generally kids are going to end up going to the school that is the neighborhood school of the parent that they live with most of the time. Sometimes parents will have the resources to make private school decisions, but then if there's an expectation that both parents are going to be contributing to the cost of that, then there still needs to be some buy-in by the other parent. Whether or not somebody has to go to summer school, or if a child has special educational needs, working through the IEP, that may be then the responsibility of just the parent that's given that decision-making responsibility. And for health, that would be kind of basic medical, dental. If child has mental health needs, trying to make decisions about an appropriate course of treatment. Again, generally the other parent is going to have access to what's happening in those cases, but one person, if that is what the parenting plan provides for, can be responsible for making those decisions. Religion and extracurricular activities. Now, extracurricular activities, a couple things to keep in mind are that if extracurricular activities are going to interfere with the parenting time of the non-primary parent, then that will have to be addressed somehow. Sometimes there will be makeup visits, or sometimes the non-primary parenting time parent will be on board with those particular activities. But those are issues that have to be worked out. You can't just kind of over-program kids so much that they never see the other parent if that parent is entitled to parenting time under the plan. And also, if both parents are going to be sharing the costs of extracurricular activities, then they need to work through those expenses and figure out what's reasonable together. Parenting time. This takes up a lot of the space in that parenting plan. And again, that parenting plan, I think, has been sent to people who pre-signed up for this, and otherwise it should be available at the website. But this addresses what the regular weekly schedule is going to look like, or sometimes people work on bi-weekly schedules instead, like if it's kind of an uneven pattern of days. So you address the main weekly schedule or bi-weekly schedule, then also school breaks. A lot of times something is different during school breaks compared to the regular schedule. A very important factor is how far apart the parents live. I mean, if they live in the same town, it creates certain opportunities that would be much more difficult if parents are 2 hours apart or 2 states apart. But assuming that they're within reasonable driving distance, then a lot of times, if there's regular weekly parenting time, it doesn't change as much during the summer. But again, that just depends on the preferences and agreement of the parties. Holidays, there's a lot that can be included in that, or short, depending on the preference of the parties. Transportation, who's responsible for getting the kids and picking up the kids? Typically, it's a shared responsibility, and in my experience, often the parent who is beginning their parenting time would be picking up the kids. But sometimes the parties are far enough apart that makes for a really long trip, and so they end up meeting in the middle at a gas station somewhere. So, but usually you should think in terms of shared communication responsibility. And then one of the things in the parenting plan is what kind of communication can the parent have when their children are with the other parent. And if things are going well between the parties, it doesn't necessarily have to be limited. You know, the expectation would just be that that communication happens at reasonable times. It doesn't interfere with bedtime. And nowadays it would usually include video chats. And but if the parties are having a hard time getting along with each other, sometimes even details for those calls need to be very specific in terms of, you know, who's responsible for making the call, when, what night is it going to happen, what time is it going to happen, and all of that can be addressed in the parenting plan. And then there is a provision in the parenting plan, a right of first refusal for childcare, and a lot of times that doesn't make any sense anyway, based on the work schedule of both parents. But it is something to be addressed, particularly if, like, one of the parents is not employed. Sometimes it would be appropriate for that parent to have more parenting time, rather than have the child go to an independent child care provider. So, and then actually also in the parenting plan, sometimes what needs to be addressed is how the parents will communicate with each other. There are different co-parenting apps that people can use. Sometimes, again, my context is thinking about it, orders of protection in situations where there's been abuse. And so sometimes parenting apps are very useful because there's a complete record of all communication that happens. And also a place to record scheduling things, you know, when somebody's basketball game is, or when there's a doctor's appointment. You can even include things like what size shoes is your kid wearing now, and so it can be very helpful. And there's a number of really good apps that are out there for free. But what happens if, after going through that process, and you've gone to Children First, You've been through a mediator, the guardian ad litem makes a recommendation, and the parties are still not in agreement, then what's going to happen? What is the judge going to be looking at? And the judge will need to resolve, among other things. I mean, there may be other property issues as well, but when we're talking about this key issue of allocation of parental responsibility, it's going to be who's going to be the decision maker for those 4 areas, and then what is going to be the schedule of that the kids spend with one parent versus the other parent. And in general, there's this broad best interest standard. What's in the best interest of the children? Again, the judge doesn't, in terms of parenting time and parental decision making, doesn't really care too much about what the parents want. I mean, in terms of their own ego or whatever, everything is going to be focused on what's in the best interest of the children. But that's a very broad and relatively vague thing. And there are some statutory guidelines for what the judges are supposed to look at. And this was the other 2 handouts that was forwarded to people who pre-signed up for this and should be available at the website. And there's 2 long lists of things that judges are to consider. And there's the first list is the best interest standard considerations for decision making. The second list was best interest considerations for parenting time. There's a lot of overlap between those 2 things, and some of them are pretty obvious. Some of them may be a little bit more surprising, or but in both cases, the wishes of the parents are considered. But the reason why you're still at this point and there's not an agreement yet is that the parents have different ideas of what's best for their child. So then those kind of balance each other out. So then what's left? Well, you look at the history, you look at how well the child is doing in the current circumstances, the preferences of the children, has some relevance, but the maturity of the child is important, how they articulate what the basis of their preferences are important, and then there's just a lot of practical considerations as well. So I'm not going to go through that whole list, but just to know that those are important considerations. And if it gets to the point where a judge has to resolve those issues, then they'll probably make their ruling analyzing those as they come to their conclusion. So, all right, I'm just going through at least questions that I'm familiar with. Ones that get posed to me, some of them that get posed to me. How long will it take to do an allocation of parental responsibility case? And that depends. I would say if the parties are kind of know what they're planning on doing and are very prompt about things like completing their children education class and are able to do an agreed parenting plan quickly, it could take as little as a couple months. And I would say it can take as long as 18 months or more. It shouldn't take more than 18 months because there's actually kind of guidance from the Supreme Court that these decisions are supposed to be given a high priority because kids are getting older, and it's not good for anybody to have this drag out and have uncertainty hanging over people's head. So it is a high priority case, but as you can imagine, we just talked about what some of those steps are. It can take a long time to move forward. So how much will it cost? Well, it depends. Just to file a divorce petition in Champaign County, for example, currently costs $306. Then there's the cost of serving a summons. There's cost for the children first class. There's cost for the mediation. The limited guardian ad litem costs $460 each. And then that doesn't even address the issue of attorney's fees. The organization I work for is a nonprofit, and we don't charge for our services, but we only serve low-income individuals, and we cannot help even more than a fraction of all the low-income people that could benefit from assistance in this area, because there simply just aren't enough attorneys available to handle the demand. So we're, as we take new cases, we have different priorities, and we also have to do income screening, and we're looking if we've represented either party at some point in the past, and if we have, then there may be a conflict of interest. So there's a lot of people that we aren't able to help. So if somebody has to hire a private attorney to do a custody case, that can be very expensive, and I'm actually probably not the best person to answer that question, how much it would cost, but it can certainly cost thousands of dollars. Is there standard parenting time? Well, I would say the answer to that is yes and no. In each case, again, there's this best interest standard is going to be applied. But, you know, if the parents can cooperate with each other, if they have healthy relationships with their kids, and don't live a huge distance away from each other, then I would say a pretty typical parenting time schedule for somebody who's not the primary parent would be every other weekend, maybe a weeknight, like Wednesday night, get together after school and for supper, and then alternating holidays, and 4 to 8 weeks in the summertime. But again, each case is going to look at specific facts and circumstances and figure out what's best for the families involved. When can a child decide which parent they want to live with? Well, the real answer to that is when they turn 18. Prior to that, it's going to be up to the parents to come to an agreement or the judge to make a decision. The child's input is relevant, and usually that information is going to come in through this guardian ad litem. But the weight to be given to that is going to vary a lot depending on the age of the kid. But there's no magic number at which once a child says, well, I just don't want to do that anymore, that's something that they're really permitted to do. And so it's important for parents to be working as hard as they can to support the interest of the other parent in terms of having quality time with their child, and to try to make that something that's a positive experience for everybody. Does non-payment of child support have a bearing on parenting time? I wish I had $1 for every time I heard somebody suggest to me that they thought it should, but it doesn't. It's because they're two separate things. Payment of child support or non-payment of child support is a separate issue from parenting time, and non-primary parents generally are going to have a responsibility to pay child support. If they don't, again, it's separate from their right to enjoy parenting time, and so those have to be dealt with separately. One can't be used to coerce compliance in the other context. And then here's just a couple of specific complications. So mostly here we're talking about parents who are trying to figure out who's going to be the decision maker and who's going to be primarily overseeing the children on a day-to-day basis. But sometimes non-parents are seeking custody. Sometimes it's grandparents, and the complication here is they have to have something called standing. So generally, the assumption is that biological parents are the best option to take care of their kids. And I've seen this, especially like maybe if one biological parent dies and perhaps that parent's parents have been very involved with the kids, but now the biological parent who hadn't been the primary parent before is stepping up and says, okay, I want to be the primary parent now. Then that can be a real challenge for those non-parents seeking custody. And another complication is if one parent decides they want to move out of state. Again, by agreement, they can certainly do it, and sometimes they can make certain concessions, like they're going to make sure they provide all the transportation and extra time in the summertime. And sometimes parties can work it out, but other times this is a real sticking point. And the difficulty of doing that is going to probably depend a lot on what the prior relationship was of the parent who is not moving. If they've been very active since the separation and have a close relationship with their child, it may be very difficult to get approval to move out of state because, and I think that's probably appropriate. That the burden of proof is going to be on the person seeking to move out of state. They have to demonstrate it's in the best interest of the child, and it's going to be a steep threshold that they're going to have to meet to establish that if that child has a good relationship with with the other parent. And this can be a complication. So children born during a marriage, but if the husband is not the biological father, say the parties were separated for a while, hadn't gotten divorced, another child was conceived and born, and the legal presumption is that the husband is presumed to be the father. And if that's not the case, in certain counties, parentage will have to be established before for example, you can complete a divorce. So all the children have to be accounted for in that divorce process, even if they are not the product of that marriage. That's not typically true in Champaign County. You can just indicate that there is this extra child, husband is not the father, and then you just address the needs of the kids that are of that marriage or of that. And you don't have to deal with this other complication. But again, in other counties, in particular Vermilion County, this is a problem. That's a kind of a quick overview. There are many resources that are available online. The parenting plan that I distributed is from the Administrative Office of the Illinois Courts, where there are a lot of different kinds of forms, and their website can be a little bit confusing, but if you go through this sequence of links, forms, and under forms, go to circuit clerks, and under circuit courts, go to divorce, then there will be a host of forms that are available. I included the Land of Lincoln Legal Aid, Legal Advice and Referral Center, which is, it's staffed by attorneys Monday through Friday, and it's kind of the point of entry for new clients generally calling our office. In Champaign County, there's actually a staffed self-representation help desk where you can get forms and legal information. And then Illinois Legal Aid Online has a great website with a lot of information about different areas of law, not just family law, but a lot about family law, and kind of guided steps to completing forms that they can help you with. So, and I think I will stop at that point.
Thank you, Valerie. I guess I hadn't thought of the difference between counties so much. So that's interesting that you point that out. I thought states would be obviously different rules and things to follow, but the differences between the counties just did not cross my mind. So I appreciate you sharing that. I'm going to stop just for a second before we continue or we wrap up for this evening. If there's any questions, you can use the chat, or if you want to raise your hand and let me know. I'm happy to let you talk and ask the questions. So let's pause for a minute, see if we have any takers. All right. And again, everyone should have received those documents, and you can follow up with me, my email, or you can email the library at info, that's info@champaign.org. We can always get those to you as well. Valerie, thank you so much for this presentation tonight. This is important information for people to have and feel confident and comfortable in these types of resources, and so it's really important work that you're doing, and thank you again for all that you have done at your many years at Land of Lincoln Legal Aid. Again, thank you for tuning in tonight. Champaign Public Library is offering a variety of webinars around crafty adults and career and businesses, business programs. So be sure to go to champaign.org/events to sign up for any of those. Again, we are mostly in webinar mode right now and hope to change over to in-person programs as things continue to improve with everything going on. So without further ado, I will wrap it up. And again, thank you, Valerie, for joining in and giving a wonderful presentation tonight. And that's all. Thanks so much.
Okay, thank you.